Dismissed. If your case is related to that, you file a notice of related case. It is a mandatory obligation. 6, you need money. $120 is what it costs today to file a complaint in federal court. And 7, you've got to take some extra copies with you. Ordinarily, the clerk's office will take the original and 1 copy. It is customary in federal court to have a courtesy copy delivered to chambers, particularly of important documents that you're filing, such as complaints and key motions. In addition, you want to, whatever copies you want to have conformed and bring back to the office. I'm going to give you maybe one of the most important practical tips I can give you in this course for the Northern District, because I'm going to give you the name of the person to call if you have questions during any portion of this process. He gave me permission to do this. I talked to him today and warned him that I would be doing this. His name is Bob Monet, M-O-N-E-T. His number is 556-3031. He can save your life in federal court. And I think what Bob said to me on the phone today is instructive of why the federal court can be different. Bob said, please give them my name and tell them that if we can work together, we can make this whole process much easier for both of us. And he will do that, and he will tell you how it is easiest for the clerk's office to receive things. He won't give you legal advice, but so much of what we need to know is procedural that Bob can help. So feel free to give him a call if you have a question. He'll either answer it or refer it to someone else on his staff. So now the complaint's all done. It's ready to take out to court. You've got to realize when you go to federal court and you file your complaint and you get your summons stamped by the clerk's office, they start giving you things back. And if you're the plaintiff, it's your responsibility to make sure that the things you're getting back are dealt with and, in fact, served on the other side. Very briefly, what you get back is a notice of right to consent to the disposition of the case before a magistrate, which is a voluntary stipulation that can be signed. You get General Order Number 17, which I won't go into, relates to service of process, not particularly important. It essentially says that the ordinary rules of process apply and don't bother the United States Marshals for this. You will get, in every case, an order from the judge to whom you've been assigned. And you'll find that out just as you file the complaint. They will tell you as you file the complaint which judge you have drawn. And you will get a copy of that judge's order setting the first status conference in the case. We're going to talk about status conferences in a few minutes, but you'll get an order setting forth what should be done to prepare for the first status conference in the case before the judge. And you may, with many of the judges, get some other standing orders or guidelines. Judge Schwarzer has a little booklet, one of the federal judges, on how to practice in federal court. So actually, it's effective and useful to how to practice anywhere. But the judges may have guidelines that they want you to follow just in their court. And those guidelines will apply generally only to their court. And it becomes the first part of the process, which is critical, is trying to figure out from the minute you've been assigned to that judge how that judge wants you to practice and how you can be effective, not just in the federal court as a whole, but before that particular judge. Service of the complaint is covered in the local rules and also Federal Civil Procedure 4. I won't go into it. You file the original summons, proof of service, and you're ready to begin your case. There's one word of caution that I want to be sure that I mention to all of you in connection with preparing a complaint, and it goes back to something we talked about earlier. It's Rule 11 of the Federal Rules of Civil Procedure. Because one of the most important requirements of Rule 11 has to do with the certification that we all make to the court when we sign the complaint. Actually, when we sign any paper that's filed with the court, but it's particularly important with the complaint. Because when you sign a complaint, you are certifying to the court that you have conducted a reasonable inquiry into facts that support the complaint. And that reasonable inquiry may be looked into someday. Someone may come back and question exactly what it was that you did to support the allegations that are in your complaint. Similarly, you are certifying that you have conducted a reasonable inquiry into law, and that the document you're filing embodies existing law or a good faith argument for extension, modification, or reversal. And lastly, that the paper is not interposed for any improper purpose. This is the end of the second half of the first cassette.